Hi everyone. So I'm Sumesh, and we have Safir Anand with us. So I'll just get on to the first question. So Safir, as you've been heading a IP firm, and so what's been your journey so far, especially in times of the changing landscape in the last few years?
Well, I'll say fascinating for many reasons. One is the fact that intellectual property, although our firm was set up in 1923, intellectual property's evolution has started in so many interfaces that every day of my life, I'm a student of law and I'm a student of things beyond law. For example, I could be dealing with a client that has a technology interface and he could be talking about machine learnings and algorithms, and I could be clueless before the meeting and be educated in the process and then frame an opinion around what we do. And it's like getting paid to get educated, which is like phenomenal. The second part is that intellectual property is at the heart of people right at the top. So, which could even, when I say top, it doesn't necessarily mean the owner of the business, but somebody who's very innovative. It could even be a kisan from a basic place who come and says, I've come out with what is called a jugaad innovation or something of that sort. So you're always meeting a group of constructive people who always think in terms of a vision. You are aligned to a vision thought process, and then you become the strategist to either protect the vision or to scale it up or to safeguard it from any risks, etc. And the third part of it is that in order to reach this milestone, you obviously read diversity. I mean, I read more books now which are not to do with law and to do with technology and disruption and gene science, mutation, in order to keep updated. And that actually empowers me to feel that, I'm part of an ecosystem truly as opposed to being in a single, practice area.
That's been very interesting. So moving on to the next thing, how do you feel and what's your, with the onset of technology and digitization has been the impact on IP? Because IP has been something, prevalent from pretty long, but with the advent of digitization in the last few years, typically there's been a sea change to how IP practice or, it has the new challenges which are coming up.
Yeah, so there's a positive side and there's a negative side, and I'll start with the negative side. Because of the impact of digital, it has become increasingly easier for violations of intellectual property. For example, I'll take up the publication industry. The industry anyways was getting impacted by print books because they went into digital and the cost of the books came down, therefore the royalties came down. Maybe somebody could argue that there was a greater sales and therefore the royalty was compensated, but in a real sense, the royalty rates came down. People stopped reading books, they went to blogs and they went to YouTube and TED Talks and many other things. And then there was piracy, like just to give an example, when Dr. Raghuram Rajan's book was released, the same day it was circulating in WhatsApp groups and you could just read that book, and I don't think that Dr. Rajan would have got any sufficient amount of royalties. The same thing happens with peer-to-peer sharing. When Napster came a few years back, the entire music industry suffered because you could upload files and I could share files till the time Napster got into a legal problem, and they said that this is not to be done. Same thing with a lot of people in the creative field who make logos and other things. I mean, if I'm a creative person and I make a logo and I present it to the company, I expect that the logo is going to be original. But with the internet, there is so much of information that is flowing from one place to another that a contra claim that this already exists or substantially similar to something, etc., exists. So piracy is, a problem that has surfaced. In order to tackle this, there has been opportunities. Just to give you an example, theoretically, while we say that the book industry has suffered or in terms of collections because of digital, in real terms, the book industry has grown. And the reason why it has grown is because of the ease at which books can be read, and maybe the cost factor and the fact that things, when you go on a Kindle, you can underline things, you can see how many people are reacting to things like that. Apple has done a fantastic job with their music store, and as a result, that 15 rupees that you pay for a song or 12 rupees that you pay for a song is, or when you go to Spotify and other things, is now becoming far more legitimate in terms of that. In fact, in some of the technology that Apple has deployed, if you on your computer download a song that is not legal, but you have iTunes, in all probability it will remove it from your playlist or not allow you to copy it because their softwares are designed in that way. So the negative side has been this. There's also a lot of plagiarism. And I won't mince words here, and I'm not trying to make a judgment here, but I'm trying to share something that happened just yesterday. There is an extremely famous author called Nassim Taleb, which you have heard of. He's regarded by New York Times in the 10 most influential authors of all time. Yesterday, Nassim Taleb got into a conversation with a guy called Rolf, who's written the book of The Art of Thinking Clearly, where he has on public forum alleged plagiarism. And he's put the two, the picture of Rolf's book and his own statement and said, let the audience decide. So now there is also this trial by media, trial by public that has started even in fields of intellectual property. And I know this happens a lot in the fashion industry. A lot of people, when they have plagiarism, they may not even come to a lawyer because the designer may be famous or the design house may be famous. They'll put up an image and say, this is what I did, and it's recorded. I did it in 2016, and it got publicity. And this is what this gentleman has done yesterday, or this lady has done yesterday. And the public comes and says, shame, 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 and things of that sort. So there has obviously been a difference in the way intellectual property is being treated on the digital side. The advantage now, it's made the life of brands very easy. Well, I'll say arguably easy, and I'll try and explain why that. First of all, it's easier for brands to get into public awareness. It's easy for intellectual property to be recognized. Or somebody does a wacky campaign. It's like almost like what TikTok is doing. TikTok does the most silly things and it gets public and everybody starts sharing it. The same thing happens when good ads are made, good thought processes are made, good ideologies are made. It allows for far greater reach. The barriers, geographical barriers have been broken because now internet is a free world for everybody and therefore you don't have to get into issues. Jurisdictions have become easy because of the access of information to everybody. So the overall value of brands is going up. In fact, if you read the Business Standard this morning, it spoke about how the disparity of income in India is actually growing with rich getting richer and that's because if you analyze, the rich are the guys who actually own the intellectual property. It's not the commodity companies that are growing. It's not the steel companies that are growing. It's the differentiated companies that are based upon intellectual property that is growing. In fact, just before I pass it on, in a study done, which was even tabled by, I think, WTO or somebody, 90% of the wealth of the world is now in intellectual property. And according to some of us, and of course I have a biased interest because I practice that, I think that number will change closer to 95, 96% in the next 2 years.
Thanks for that. But on this note, coming to the next issue is, as an IP lawyer, do you feel the Indian IP regulations have not been able to cater to the growing digitization and intellectual, because still it's perceived that, the IP laws are still very archaic and they've not been able to keep pace the way globally we are going into digitization. Even data protection laws are pretty much at a nascent stage. So what are your views on this?
For the benefit of those who want to pursue and want to read judgments, you should read some of the judgments that have come out of the Delhi High Court recently, particularly a judgment that Justice Pratibha Singh has written, where intermediary liabilities have been realized. So that basically means that if I'm a website and I'm hosting a product there and that product ends up being counterfeiting, they're saying the activity of my hosting the product makes me as the intermediary also liable. And this essentially means that the courts are coping up with the changes and are saying that the liability issues are not going to be limited only to the manufacturer of the goods, and the concept of selling will go to intermediary.
But something like registration for design, which is almost like non-existent. Unlike in the West, where it's almost like a norm that any designer, anyone would go and register their brands, register their designs before launching.
Well, some part of that fault lies with the designer fraternity because they don't apply for protections and then they realize that they don't have a business value because of that. And wherever they have applied, there are lots of precedents of restraint orders. And like I said, there's now public trial that is happening and a lot of other methods of solution are in place. I think in another very critical judgment that came out of the Delhi High Court, they said that the jurisdiction is not going to be limited to India. And this is phenomenal because typically legal jurisdiction is going to be limited to India. They said that if a server is located in India and distributes anywhere in the world, we should be able to stop the distribution all over the world because the server was located in India. So that's, I think the courts are taking cognizance of this, and we'll now see what happens in the amendments to the privacy laws, and whether you would have read in today's paper that you will now have to move an application before the government department in order to get declassified as personal information and to the right of privacy. Whereas in the European Union, as an example, you apply to Google or to one of these service providers like Facebook and say, I please declassify my information. So the law is evolving, and so is the amendments in the law.
No, that's interesting. Coming to the next question, what's your views in view of, the impact on law firms and lawyers, particularly vis-a-vis artificial intelligence? Because now, at least in our country, we're not so much impacted, but in the West or especially in the US, you've been hearing stories where law firms have started deploying artificial intelligence, and especially research work, early the lawyers, the paralegals, all this work's been replaced by artificial intelligence. So is it a threat? You feel like IA is gonna take away the legal jobs, especially for a young generation who just passing out of law schools and law colleges?
Yeah, so Boston Consultancy did a very interesting study where they made a pyramid, and at the bottom of the pyramid are paralegals, and then there is junior lawyers, senior lawyers, and at the top, what you may call as strategists, GCs, and other things. And they said that the paralegal role will perhaps come to an end because the ability of machines to, give you a lot of data is setting in, and that role is getting more and more pronounced. I think from a lawyer's perspective, it's actually becoming an opportunity because now the lawyer is empowered with more data points. And not all data points are going to be on the same side. There would be contradictory points, there would be validations and invalidations and other things. And therefore the lawyer is more equipped to do an analysis, and because he's more equipped to do an analysis and the accuracy of his analysis is going up, the value that he brings to the system will keep going up. So I think lawyers will evolve and will benefit from this transition as long as they're able to utilize all that big data and put it to greater amount of use.
Yeah. Thanks. But you feel it's gonna be will also result in loss of jobs, or it's an opportunity for lawyers to excel?
For paralegals, maybe. For lawyers, I think it will increase the scope of disputes. And see, also the law will change. Like when digital came, all of a sudden the new levels of piracy has come. When machine learning comes, I'll just put this to you in order to engage you. Now, robos are being created all over the world, and robos may be interacting and doing things. Now, who will own the rights to the robo? So there'll be disputes. Somebody will come and say, in some countries, like for example, New Zealand, they've amended the law to define copyright as something that is capable of being created by machine learning and artificial intelligence and robots. And in America, they say that the robots will also have rights, but the rights will ensue from the person who has programmed the logo or who programmed the robo or makes him do that activity. So there'll be new levels of dispute. Also in the internet world, there's a massive amount of collaboration. Because I may put up something and there may be a huge number. I mean, I can go to Business World's blog and I can write something there, and there can be huge levels of collaboration, and Business World may get a lot of traction because of what I've written, but I may turn around and say this is collaborative intellectual property and not an individual intellectual property. So disputes will in fact rise, which will make it more interesting for lawyers. Also risks will rise, which will make the contractual practice benefit, and new technologies will come, so lawyers will have a new game to sort of participate in.
Thanks, Safed, for all your insight. Does anyone have any questions?
So, my name is Prakhar Agrawal and I am a student of law from National Law University, Nagpur. Sir, now we are seeing that companies are using smart contracts and blockchain technology in order to protect the intellectual properties of the owners. So, do India have proper regulations to regulate smart contracts and blockchain technology, and how disputes arising out of smart contracts and blockchain technology can be resolved by courts or through arbitrations, and what are the nitty-gritties in such dispute resolution mechanisms?
So, in a sense, your question has an answer in itself. The very fact that there is lack of clarity on how a blockchain or a contract would be resolved is an opportunity. And because it's an opportunity, there will always be two sides to it. There will be a law firm that will interpret left, another law firm that will interpret right. It will go to a court. The court will come out with a decision. The decision will never be accepted by one party, and it will result in an appeal and then perhaps an amendment in the law. And therefore, the field or the snowball effect will continue. Now, when you look at blockchains and other things, there's a complete lack of clarity on whether blockchains are well, the government wants blockchain, the corporates want blockchain, but blockchains also work on other mechanisms which are not considered to be legal in the country. So the point is, it will have benefits to some extent, and it will have a lot of ambiguities in other extent, and the opportunity will continue. So the answer is going to be specific to the problem and not general to the issue at hand. Now, as far as contracts are concerned, a lot of the world is not making contracts on the same terms because the world has changed. There are new forms of collaboration, there are new forms of global exchange, there are, the things of that magnitude that is coming, like I said, the interface of science, molecules, risk mitigation. Now today I cannot escape and say I was not aware of the fact that the rights belong to somebody else because I did have the basis and the information to search in several search engines that a lot of professionals run. Algorithms, people create, a lot of the new age companies, fintech companies particularly work on algorithms, and algorithms really are not protected under patents. So you need a smart lawyer to come and tell you how he's going to create the walls around, and therefore the answer is going to be specific to the needs of the client and what the lawyer will think about.
Thank you, sir.
All right, thank you so much.
Yeah, thanks, Afir, for giving us a lot of insights on the IP and the changing landscape vis-a-vis digitization.
Thank you for having me here.